Check, check, check. Check, 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 check. Yeah. Yeah. Check, check, check. Here you go.
Thank you.
I'll I'm gonna give this to you. Okay. Welcome, everybody. I want to welcome everybody to tonight's conversation. It's a really important one, and we're really privileged to have three esteemed panelists who I'm going to introduce in a moment. I do want to thank Brian Sterling, who really kind of introduced me to Bill Traynor, and together we came up with this idea together. And so thank you very much for making tonight possible in that way. We are right now in a pretty scary time, and that probably is an understatement. And we could talk about the moment that we're living in a lot of different ways, but the idea of where our freedoms lie, freedom of speech, freedom to gather, freedom to express ourselves, I think is one of the fundamental pieces that is under attack right now. And we as Americans need to better understand exactly what the edges of that freedom look like. And so freedom and education, specifically higher education, is one of those areas. It's an important case study in understanding where that freedom is, where it erodes, and what can be done about it. And so we're privileged to have three panelists up here who are going to be addressing that question tonight. Bill Traynor is a leading constitutional law scholar and longtime dean of both Fordham Law School and Georgetown University Law Center, bringing a deep expertise in university administration and the evolving relationship between universities and government in moments of political and cultural conflict. He recently found himself at the center of a national controversy after the interim U.S. Attorney for the District of Columbia demanded that Georgetown Law, quote, eliminate all DEI from your school and its curriculum, bringing urgent attention to questions of governmental power, academic freedom, and institutional autonomy. Dr. Jonathan Koppel, president of Montclair State University, is a nationally recognized scholar in public administration and global governance, known for his emphasis on public service and community engagement. Since assuming the presidency of 2021, he has led record enrollment and retention, overseen the historic merger with Bloomfield College, and guided Montclair's strategic reorganization to better serve today's students as one of New Jersey's largest public universities. And our moderator tonight, though honestly, he's also kind of one of the panelists too, you'll appreciate his expertise, is Paul Fishman, former United States Attorney for the District of New Jersey and respected voice on civil rights and public law. He will draw on his years of prosecutorial leadership and engagement with complex questions of institutional responsibility and the rule of law. And this is the second most prestigious panel that he is moderating, since he also was the one to moderate my book talk last year when my book launched.
And honestly, that was better because I got a free book at the end. And I will say that one, as you all know, because I'm sure the rabbi has sent everyone a copy of the book. The book is an exegesis on pragmatism, of the pragmatism of Judaism as through the eyes of the rabbis of 2,000 or more years ago, if I read it right. The advantage for me about this one is that actually I know a little bit more about the Bill of Rights than I knew about the Talmud when I started each of these programs, because I did study the Bill of Rights in college and law school, the Talmud not really so much. But I do want to say a quick word. Jonathan and I have become friends since he took over the presidency of Montclair State. We've had a number of remarkable dinners together talking about law and politics and universities and our families and so forth, and he's become a friend, which I'm very excited about in my life. And Bill Traynor and I have known each other since for about 50 years. And because all things in life like this come back to Reform Judaism, in the summer before my senior year in high school, I participated in a program called Mitzvah Corps that many of you may know about, right? Started by the Jersey Federation of Temple Youth, sort of a little urban project for 6 weeks in the summer, where at least in the summer of '73, there were 19 of us who were in high school from various synagogues around New Jersey, and overseen sort of nominally by a student rabbi and his wife. And that summer, my roommate was a fellow named Russell Pierce from Somerville. And Russell Pierce, the following year, roomed with Bill Traynor at Yale. And so I've known Bill since Russell went to Yale, which is a really long time ago. And so I'm happy to be on the panel with both of you. So I think it would be useful to start kind of with two things, and I'm going to ask you both to each of you to sort of talk a little bit about each of them sequentially. So I want to talk about freedom of speech and the First Amendment, and I want to distinguish between that and academic freedom, which are two related but not identical and overlapping topics. So Bill, as a constitutional scholar, why don't you start with kind of the rubric that we all need to know, the basic rules, the basic principles of the First Amendment as they would apply to campuses of higher education. And you have like 1 minute. No, you have.
So, one of the fundamental differences between Georgetown, where I am, and Montclair State is that the First Amendment, kind of by its very nature, applies to government institutions like state schools. Yeah,
that's better.
Okay. So the First Amendment applies to government institutions. So kind of by its very nature, Georgetown is not bound by the First Amendment in the way that Montclair State is. At the same time, we both try to live by the First Amendment and also respect academic freedom. Those are both kind of core principles for a university. And there's also a difference. So we were talking about this before, and I think Jonathan can kind of go into this in more detail. But academic freedom would be, if I'm teaching a subject, I can take a position and we don't kind of regulate the position I take with respect to the area I'm teaching. So if I'm teaching constitutional law and I have a take on the First Amendment that the dean disagrees with, the dean doesn't come to me and say, you can't do this, right? On the other hand, if I'm teaching math and I have a take on the First Amendment, I don't have the freedom, academic freedom, to talk about something that's kind of outside of my area of expertise. So that's kind of one dimension, which I think is important. The other is, even though we have no obligation to have diversity of opinions, again, going back to constitutional law, everybody could have the same take on constitutional law. We try to make sure, one thing that I'm committed to is trying to make sure that there's a diversity of opinion. So we don't have a First Amendment obligation, but I try to make sure that we have, on kind of the big issues of the day, people who have a range of perspectives. And that's tricky because, again, I think, just my experience, and I think most people in education's experiences, the faculty tends to be kind of strongly to the left. So in order to get kind of ideological balance, that's something that you really have to focus on in order to make sure that happens. And again, it doesn't kind of happen of its own accord.
So first of all, thank you for having me here tonight. Thank you, Rabbi Katz. It's a pleasure to be here. Hopefully we'll have 45 more years of friendship, Paul.
I certainly hope that would be great for me, for a whole other reason.
Yeah. So I'm personally not counting on it.
You might live that long. I'm not. Yeah.
So we'll catch up. So I'm really glad we started here, as I said, because this gets all tangled up in ways that are really obfuscatory, right? So first of all, I really appreciate the public-private distinction. So from a public university point of view, we're very limited in our ability to regulate speech on campus. That doesn't mean zero, and we'll talk about the ways in which we can and must regulate speech on campus, but we can't make any rules about what a protest or whatever says. That is to say, we have to be content neutral with respect to our regulation. A private university isn't bound by any of that. If a private university wanted to have no protests on campus, they could. The First Amendment, it gets used all the time. The First Amendment doesn't apply to any of them. In some respects, that makes it easier for us, public universities, because we are not allowed to stop people from protesting and speaking. And we'll talk, I think we're going to come to a little bit about how we regulate it. Yep. That doesn't have any implication for what happens in the classroom. And the idea of academic freedom and what happens in the classroom isn't because an employee has First Amendment rights to say whatever they want, whether it's in a math class or a science class or whatever. And as Bill said, if a math teacher gets up and starts spouting her political opinions about X, Y, or Z, that's not protected. And we've had those instances where we have to intervene and in some cases even end the employment of people who are using their class as an inappropriate venue to voice political opinions that have nothing to do with the curriculum. Now, having said that, I can't, and here's where the First Amendment does affect faculty. If a person on campus were to join a political party or engage in some sort of speech activity, I can't punish them for that because that would be a state violation of their First Amendment rights. And it could also be the case that it overlaps with their academic freedom because I can't dictate the opinions or the conclusions that somebody has as an academic. So I'm not going to intervene in a class and say, no, your version of history is wrong if they're a history professor, just as I'm not going to dictate what a sociology professor says or what a math professor says unless it's grotesquely wrong or destructive to the content of the material. So there is some overlap in terms of your ability to make judgments of faculty based on their First Amendment freedoms as employees of public universities, but the reasons why we allow protests on campus have nothing to do with academic freedom. That often gets expressed that way. That's a confusion of concepts.
Right, and to put it in kind of concrete terms about the public-private distinction, some Catholic schools, not Georgetown, but some Catholic schools want to hire faculty who are Catholics, who have a certain view of the doctrine, and that's a prerequisite for being hired. Again, not at Georgetown, but there are Catholic schools that take that approach. That's not content neutral. So, Montclair State could not do that. So that's a fundamental difference. And again, it's because the First Amendment doesn't apply to private institutions.
It is not a coincidence that the last two presidents of Montclair State have been Jewish. We should think about that. No. And Seton Hall Law School actually now, as you both know, has a Jewish dean, Ron Weich, the first time in its history, which was I think quite more remarkable to me than if Georgetown had a Jewish.
No, and I have to say, I'm Catholic. I'm the first Catholic dean of Georgetown in 40 years. Everybody else was Jewish. So we are far ahead of Seton Hall.
Anyway, so you talked about a little for a second, Jonathan. So let's talk about time, place, and manner regulations generally, and maybe, Bill, you can talk about the origin of time, place, and manner regulations with respect to free speech and what that means. And then, Jonathan, maybe you can talk a little bit about the way you've implemented that concept recently on your campus.
Now, why don't you start talking about what you have?
Well,
How do you want to do it?
You can do whatever you want. I'm just here to facilitate. If he wants you to go first, go first.
So, but
Maybe
just,
not.
yeah, but on time, place, and manner restriction, that's something that you can legitimately do. You can say that you can say certain things, but you're going to restrict where you can say it and the context. Again, that's a kind of a well-established First Amendment principle for probably 100 years. So again, there are things that you can say. You can't say that, in this context, but you can say it in a different place.
You couldn't, for example, I think, say that people can only have the right to protest on Saturdays, because that might end up discriminating against people. You could say that everybody can only protest from 8 in the morning until 6 in the evening. because otherwise it's noisy and we don't have enough cops or whatever to police all this stuff. So Jonathan, why don't you talk a little bit about
So the question is, what's a reasonable limitation on time, place, and manner? And there's been a whole lot of litigation and case law on this, and so you have to have a rational, I don't know if rational basis test is the test, but you have to have a rational thinking about why you're imposing the limitation that you're imposing. So from my point of view, as president of a university, if the protest is going to interfere with our core function, which is teaching classes, that is to say, if you're going to have amplified sound systems in the middle of the campus, right next to buildings where people are teaching classes, we are completely within our legitimate rights to say, no, you can't do that. What has been generally determined is, I also can't say, yes, there's one corner in the furthest parking lot of the campus, all the way up, and that's the one spot. We've got some red stripes on the ground, and you can protest there from 1 to 1:30 in the afternoon. You can't do that either. So the question is, and we've navigated this, the question is, what constitutes a reasonable restriction on people's protest? And we've worked on our rules to come up with something that is reasonable, that protects people's ability to study and go to class and so on and so forth, that still gives people the ability to protest. Again, one of the complexities of being a public university is that includes members of the general public who just want to come on campus and protest, although we do have the rights, and we've made this in our current policy to get into what we did. We do have the right to restrict outside of the campus community protesters more severely or more restrictively than members of the campus community, which we did. And I'm sure many people here know the campus, so there's the amphitheater sort of near the entrance to the campus. We said, if you're an outside party, that's where you have your protest. And then we created a map of campus which limits people to not closer than 75 feet to the entrance. And I wanted to come up with a basis, so I used the same rules that are used to protect polling places. I thought if there's a logic to that distance, we would use the same distance. Some people think that's too restrictive. We're in conversations with an organization called FIRE, which is interested in restriction or regulation of speech on campus, about whether that's appropriate or not.
I think they're interested in no regulation of speech on campus would be fairer.
Yeah, but they recognize, look, they live in the real world, and they recognize that there's a time, place, and manner restriction, and that's valid. Let me just add one other dimension to it, because it's so pertinent these days. Universities are also under Title VI regulation, and that's now added a new wrinkle to all of this, because Title VI puts a burden on the universities to provide a safe environment for all people on campus, particularly protected classes. And so when you read about the Trump administration going after universities for not doing a good enough job on anti-Semitism and so on and so forth, generally that's going to be under Title VI, and the claim that universities didn't do enough to create a safe environment. So we have to balance our obligations under multiple constitutional and legal requirements.
Right, and so again, to use very concretely what we have, in the first Trump administration, the Attorney General was coming to speak on campus, and there was a lot of protest about it. And so we thought through, we don't have kind of a designated space, but we created a space that was a public space that was prominent, that was easy to get to, but that was also not disruptive. So some of the protesters wanted to be right outside where the Attorney General was speaking. We said that would be disruptive. And I have to say, I think he was hoping to be disrupted, because I introduced him and he had little signs. He was speaking on the First Amendment, and he had little signs that said, "Oh, the irony." So what he was hoping, I think,
Was this Sessions or Barr?
This was Sessions. This was Sessions. I think he was hoping that he would be disruptive when he was disrupted.
Yeah.
Both.
He was disruptive. That's not.
That he would be disruptive when he was talking about the First Amendment, and then he could hold up the sign saying, "Oh, the irony." So when people didn't shout him down, I think he was upset.
You were a bad host.
Yeah, I was a bad host. We could have arranged.
Exactly. So we'll come back to the Title VI and what the current administration, how aggressive and muscular it's being on enforcement in the university setting, both on academic freedom and First Amendment issues and others. But I do want to, just to not pass by the point that Bill just made about the Attorney General. There is now a pretty robust reporting of situations in which students have invited speakers to campus who are clearly going to engender not way more hostility than Jeff Sessions did. There's a remarkable one that occurred at Stanford Law School. And maybe you could talk a little bit about that, Bill, what happened at Stanford, and what the right response is, if right is the appropriate word in that context, for institutions of higher learning, regardless of whether they are public or private, and if there's a distinction, what it should be, with respect to, for example, a student group who wants to invite someone who harbors views that would resonate for most other people as Nazism,
Right.
for example.
So this is something, again, we're not covered by the First Amendment, but we think a lot about this. And our kind of basic principle is that you can't disrupt the speaker. And so we actually work a lot with kind of our security people on, if people are disrupting, what do you do? And so, so we've actually at this point, if people are disrupting, what we tell our security people is, that they can actually physically remove people. But I have to say we struggled over that, for many years. What happened at Stanford was, there was a speaker who was really just kind of barred from speaking, and one of the administrators didn't stop it, and I think basically said, it's allowing this to go forward the juice is not worth the squeeze. And so, they allowed the disruption, and it was shut down. And then the dean stepped forward and said, this is not acceptable, and also I think, did not punish the students. Right, and said, but moving forward, we will punish the students. I think our basic, principle on this is that the students, are subject to disciplinary proceedings. For law students, that's more significant than it is for undergraduate students, because we have to validate them when they apply for the bar, that they're in good character. But again, I think that's something that, where we all kind of draw the line. We have, the rule, we have, again, we had a speaker, and we said that, this is another speaker last year, we said that the protesters had to be on the far side of the green, where you couldn't hear them in the classroom. We allowed protesters to come in so long as they were silent and not disruptive and didn't interfere with the sight lines to the speaker. And then I always have a free speech monitor. And if things get out of line, if somebody's a call to violence, the rule is that they would shut it down at that point. So those are kind of the basic principles that we have in dealing with speakers. And as you say, increasingly student groups are reaching out to people who are really inflammatory to see what happens.
So we did include in our expressive activity policy the important point that you can't use your expressive activity to try and stop somebody else's expressive activity. That's not a legitimate expression, and it's not protected. And we wouldn't allow somebody to stay in a presentation if they were trying to be disruptive. And whenever we've had instances where we thought that might happen, we have our police available. As that wouldn't be our first tool, but we're ready to intervene. I think that the tricky situation for a lot of institutions, but including universities, is when you think that stopping the disruption would create a public safety hazard. That is a challenge, and one of the restrictions we place on expressive activity is if it's in a spot on campus where we don't think we can keep everybody protected, either the protesters or potential counter protesters, we don't make that spot available because we don't want to have a situation where people are unsafe. And that also includes our ability to staff, right? I don't have an infinite set of resources. I have a police department, I have a certain number of officers, and so we don't allow protests in the middle of the night because I don't have the staff to keep everybody safe in the middle of the night. And so, and that's a legitimate reason for us to say protest has to be between the hours of X and Y. So you can do things on the basis of safety, but sometimes that's complicated. There are times when people are not following the rules and people say, well, how come you didn't interfere when this person wasn't following the rules? But if you think that enforcing the rules is actually going to create an unsafe situation, that is a very difficult dilemma to face, whether you're on a university campus or in a public situation.
So you alluded to this. First of all, the expressive speech policy that Jonathan alluded to is on the Montclair State website. And for those of you who are interested in it, I urge you to read two documents. One is the policy itself, but also his letter to the community explaining why they arrived at the policy choices that they did. And it's interesting. But I live a mile from your campus, and when my kids were little, we were on your campus all the time for various sporting events and classes, and because the Red Hawk Diner had incredibly awesome pancakes and terrible service, but you could stay there for like 4 hours and eat pancakes. Georgetown a little less so, but because of where it's located, both of your campuses have not so much the law school. The law school, of course, is not on the Georgetown main campus, but the university and yours are both quite accessible to the public. And the public, it's not just accessible, there are lots of events to which the public is invited, as they would be on lots of university campuses. Are there access challenges that you have experienced either on your own campuses or that you've seen elsewhere? And I think the sort of paradigmatic example lately has been Columbia, right? Where Columbia actually ultimately shut down the walkways through the middle of campus in order to stop what they perceive to be outsiders from coming onto campus and, to use a sort of dated but sort of resonant word, agitating, right? And so do you have thoughts about what those rules can or should be, or have you had incidents within your respective geographic spheres that have caused you to think differently about these topics?
Yeah, yes.
Please.
So, one of...
I didn't even tell him I was going to ask that, by the way.
No,
Okay.
actually, he hasn't told us anything. So this is I'm as much on the edge as you are.
They're not on the edge. They don't have to say anything.
No, that's true. That's true. So I would say this is probably going back about 10 years ago. We had somebody from the Trump administration who was actually the head of, immigration at that point. And it was an event, not a Georgetown event. We were a co-sponsor, but it was something that it was basically kind of pro-immigration groups every year have a big annual conference. And they invited, the head of, immigration under Trump. And that was, we have kind of protocols that we have, which had always worked, which is that the dean of students stands up and essentially reads 3 times kind of warnings when there's disruption, and then says, at the end of the third, that you'll be physically removed. And I have to say, what always had happened, and which actually still happens, is that students don't, they will protest at the beginning, but by the third protest, they stop. And what we found then, at this one occasion, was actually people had come from the West Coast who were not Georgetown community members who did not stop. And we were actually kind of, I think, at the point of removing them, where, again, the head of immigration, I think, was kind of eager to have an incident, and so he left the stage. But, kind of our reflections on that, have caused us, to think that we really have to be kind of more proactive and kind of do what actually the university has a tradition of kind of, having the security people prepared to kind of physically remove people who are disruptive. And again, the challenge, to go back to your outsider point is that the students, we can subject the students to disciplinary proceedings. So they tend to be very responsive to that. You can't go on disciplinary proceedings against somebody who's attending one of your conferences. So that's why we had to kind of rethink our protocols in light of that.
So I alluded to this, we're far more limited in our ability to keep somebody off campus. And that's both a legal reality, but also a physical reality. You all know the campus. There's no way we can close it down. But it is true, if you go to most public universities, you're not going to find what Columbia has, which is gates that can be closed, because we can't really do that. And so it creates a much more complicated situation. We can't easily regulate. If somebody comes and they misbehave, we can put them on a list and say, you can't come on. We do have the ability to impose rules. Like I said, an outside party can be more regulated in their speech. We can say this is a no smoking campus, which we do. But what we can say is put out your cigarette. And if they don't listen, we can say, well, you're disobeying orders, and we can say, don't come back. But I can't, as you say, I can't punish them. I can't do any of those things. One of the things that this creates as a challenge for public universities is we're held accountable for stuff that we can't readily control and people we can't readily control. It is an issue for us at our campus, but frankly, not as big an issue as it is for my colleagues at Rutgers Newark, where you have, obviously in the middle of a city, people who want to use the university as a venue for protest. And there's not much you can do to stop those folks from coming onto campus and using platform. And that was an issue in New Brunswick as well, where a lot of the people on the Rutgers campus weren't Rutgers students, and yet their ability to stop that is limited. So this is one of the areas where, for a public institution, it's a little tricky. It's a little tricky to try and maintain the kind of behavior that you want to see.
So let's pivot just a little bit. Everybody in this community, I'm sure, remembers the decision that Nazis were allowed to march in Skokie, right? And the First Amendment was the underpinning of that. You can't not let people protest, even no matter how offensive their speech or their conduct in that context with their signs or whatever may be to the audience in which they intentionally place themselves. That's true on university campuses too, but at the same time, there are kinds of speech that we don't put up with in that context: hate speech, harassment, incitement to violence, intimidation, and so forth. That obviously has all become very, very problematic and difficult and heartrending in lots of communities like this one, over the question of who can say what about Israel and who can say what about the Jews, and how universities should manage that particular problem. And so, in any particular order that the two of you would like to go, what are your thoughts about how universities can or should be handling those kinds of issues?
Well, I would start, and I'll leave this, the two of you can go on this more, but the bar in general is pretty high for regulating free speech. I'm not talking about on the university campus, but in general. And what constitutes incitement and violence or the risk of violence is a very high standard. I mean, isn't it? I think it's Brandenburg is the one where basically
It's always the non-lawyer who knows the name of the case. It's just the way it works.
About as close to being a lawyer without being a lawyer as you can.
His father was the Attorney General of New York.
But isn't
so
that
exactly.
That's the KKK case, right? So you can say horrible, hateful things, and what's considered inciting violence has to be like, let's go kill that guy. Like, that's inciting violence. But saying, like, we should kill people that we don't like, that's not inciting violence. And so, as a general matter, what constitutes a legitimate basis to interfere with the First Amendment is pretty high. But this gets into the Title VI stuff. The bar is substantially, I think, different on a university campus. Now, it's not zero, and one of the things, I want to return to one point about the outside speakers. A significant portion of that sort of, I'll say angry mail, I was going to say hate mail, but the angry mail is, I can't believe you invited this person to speak. I get a lot of those emails from a very broad spectrum of individuals. If a student group that has the right to invite speakers invites a speaker, with very limited exception, I'm not in a position to interfere with that because people don't like what that person has to say. That's not content neutral. There has to be some content neutral, to go back to that base, where it's not, I allow one opinion, but I don't allow another opinion. There has to be some content neutral way to decide when a speaker rises to a level that we can interfere with. That's not me inviting a speaker to campus. That's an individual inviting a speaker to campus. By the way, you do now get into overlap. The academic freedom of a professor to invite somebody to his or her class then is an issue, right? In terms of the ability of the university to interfere with who somebody's inviting to class as a guest. If the speaker is a threat to the campus or creates a hazard or makes people be in a situation where their safety is jeopardized, then you have a basis to interfere. But it would have to be a very clear decision rule that you've established that would apply with respect to any activity on campus. And so that's the difficult part, is establishing that as a rule, not a I know it when I see it kind of decision calculus.
Right. So I mean, I've been dean at Georgetown for 15 years, and I was dean at Fordham for 8 years before. So I've done this a long time. I've never said no to a student group that wanted to bring a speaker. That's just my general rule. There are also other limits. Just for example, there's a criminal statute that has to do with supporting terrorism. Right, so it's if you bring to campus somebody who's going to be supporting terrorism, everybody's criminally liable. So that's a dividing line that's really not content neutral, but it's established by a statute. So that's another issue, that we have in mind. But as a general matter, I have students from all different perspectives, invite a full range of people.
So I want to come back to that in a second, but before we do, I represent a large urban school district, which I won't name, but that particular school district is having difficulties with various regulatory authorities over various things involving this particular space. And one of them is that one of the high school history teachers had up in his classroom a From the River to the Sea poster in high school. And obviously the rules for K through 12 systems are different than they are because of the age of the students and so forth. But let me pose this hypothetical to each of you in your respective spheres. If you walked into a classroom, Jonathan, of a history professor or a foreign policy instructor, and saw that poster in the classroom, Bill, if you saw it in a classroom dealing with international law, is there anything you could do about it? You certainly might want to do something about it, but what are the rules or what are the practices in a context like that? Because that clearly is something that people might just not find offensive, but in certain quarters might find intimidating.
Mm-hmm.
That's probably not a hypothetical I'm going to get into.
Okay, okay, okay. I don't want to put, okay, that's fine.
Yeah.
All right. Bill, you.
I think, again, for me, it's a hypothetical. That's not something that I've ever encountered. It feels to me that, that is kind of a non-content neutral statement. In other words, faculty members don't put up posters in the classroom. So this would be kind of a unique step. And it's something that, that some students would find intimidating. right? And, some students would find that it makes them feel unsafe. So, I think the kind of the first question is, with a lot of these things, first of all, I always get advice, from a range of people. So, so right now I'm just kind of reacting in the moment. But, so one thing that
Chatham House rules.
Yeah. So, so one thing that I always do as a leader is, I try to talk to a broad range of people and say, this is something I haven't encountered. Nobody else has a poster. What would you do in that? And again, it's, I also, on questions like this, I have an interreligious group that I talk to. So Georgetown Law has a Jewish chaplain who I would talk to about this. The university has a Muslim chaplain. I would probably talk to the Muslim chaplain about that. The former president of Brandeis is on our faculty. I talk to him all the time because he's both, former president of Brandeis, but he's also somebody who's very thoughtful on, First Amendment and university issues. So again, this is not something I've encountered, but just in terms of kind of how you decide to handle a situation like this, I always want to make sure that I have kind of a range of perspectives that I'm able to reflect on before taking kind of a difficult action.
I didn't mean to put you on the spot, Jonathan, but I do wonder if the standard is offensive speech is fine, but if people are offended by certain speech, then we're worried about it, right? Many of the discussions that took place regarding anti-Semitism on campus over the last couple of years obviously grew out of the October 7th attack by Hamas. At the same time, the discussions for me were often about what the line is of offensive speech in that context. If someone is making a political statement that offends people, let's take it off a university campus for a second. At what point are we comfortable saying it doesn't fit within the Skokie framework? And a lot of the conversations, at least with respect to what happened after October 7th, sort of seem to wander away, at least in a legal framework, from that analysis. Bill, I'm sure you've thought about that from the constitutional law professor perspective. How do we square those statements with what is really the existing Supreme Court jurisprudence on that topic? And then in a minute, I'll shift to what the current Trump administration's view is of things like this.
Well, I think offensive is not enough.
Right.
The bar is, I find it offensive. You have to deal with offensive.
Right.
That's part of, and by the way, I think that's part of going to a university. You should be able to confront things that you don't like. And we've allowed people at protests to have signs and so on that people find offensive. The reason why I'm not going to engage that as a theoretical is because there would be, as Bill said, there would be particulars to a situation, and I don't want to give a glib answer where we don't know any of those particulars. But in a protest situation or science, you don't have a right not to be offended.
Right.
And so that I think that should be clear, and I think there are a lot of people who believe they have a right not to be offended. And that I think that is where we're seeing some of that rub.
But there's also a line about you can't intimidate people. So, I think one of the things that the university has been grappling with is, when you go beyond kind of what people find offensive, but, people feel, intimidated. So, like in Harvard, one of the complaints were, individual students felt like they were targeted by kind of people surrounding them and saying things. So it's not the speech so much. It's kind of the making the person feel intimidated. So that's one thing when you're trying to draw the line that I think that's a line.
But that to me, we're talking about the same video, right? That went beyond speech, right? That was physically restraining somebody and being in their face and intimidating them. And so, I often, this gets into an area, and again, I hear this from people on diametrically different sides of this particular controversy. People say, well, I didn't feel safe. Hear that phrase a lot. Didn't feel safe. And what I say to that is, but you were safe, right? What actually, so I've had this conversation, it's a difficult conversation, like what actually happened? Nothing. Who has actually been harmed? No one. And so people feeling unsafe, I don't have the ability to stop somebody from feeling unsafe. There's a lot of things in the world that make people feel unsafe, but I do have an obligation to keep them safe.
Right. So there's,
Right. So if it's actually an unsafe situation, that's a real problem. But everybody has a different threshold of what makes them feel safe and unsafe. Right. So that's not the standard. I think you can make an argument in those situations, those people were not safe.
Right.
And the university was failing to provide a safe environment. I thought it was embarrassing, frankly, some of the situations in those videos. But that wasn't because of the speech. That was because of the behavior.
Right.
And so I actually think that kind of shows the difference in some fashion.
Right. So I think, just to follow up, so intimidation, that's, universities cannot permit that. Right. So that's one. I think another thing that, I've seen kind of in reading the records in Harvard that I think people appropriately complained about is kind of treatment of different groups differently. So in the Harvard suit, for example, one of the complaints was that there's a lounge at Harvard Law School that the Palestinian student group used, and then when the Jewish student group applied, they were told this is just for private use. So, so I think another dimension is, you have to apply the same rules to everybody. You have to be fair, and I think, and then you also have to apply the rules. So I think, again, to go back to, and I just was reading the Harvard complaint. There was
tell about the Harvard, who sued?
Okay. A school in Massachusetts.
Well, but they, yeah.
Yeah, so this was a student group students suing Harvard. This is not the Trump administration. And
They want to do that too. That's different.
Yeah, that's and we'll talk about that later.
Yeah.
But, one of the complaints was that, there was a student who had plausibly been accused of, physically assaulting another student, who was allowed to continue to teach without any kind of, steps against them. So again, that's something where, I think you also have to apply the rules. And, what this complaint talks about is, people Harvard not applying the rules to students in an equitable way.
It's interesting because the concepts that Jonathan was talking about before about feeling unsafe and actually being unsafe is a tricky thing, right? There are we've all been in situations just walking down a street in which someone we've been with has said, this feels I don't really feel so safe in this neighborhood. What does that mean? I felt fine. Or maybe I felt not fine and somebody else felt fine. And so, over time, the law, judges, statutes passed by various legislatures have basically adopted what we all call the reasonable person standard, whatever that means, right? And would a reasonable person under ordinary circumstances have felt X or Y, felt fear, or felt unsafe, or would a reasonable person have responded in a particular way? And in these contexts, how you define the class of people from whom you are drawing an inference of reasonableness is complicated. Because would the reasonable Jew have felt safe under those circumstances? Would a reasonable man or woman have felt safe under those circumstances? It's a tricky analysis, and I think part of the issue in this debate is that we're not coming at that conversation from the same viewpoint, I have friends who are Jews who, if they saw a poster like that, would be, in a particular context, might not feel safe. If they walked across campus and saw a particular group of people screaming, might not feel safe. Other people might feel safe. Maybe it turns on size, which is not to my advantage. But there are other ways in which you come to that analysis, and often it's experiential, right? It's based on what's happened to you before that may make a difference. And it's very difficult, I think, for any institution to have a set of rules and procedures to evaluate the reasonableness under those circumstances of what people's reactions might be.
You know, another thing though, as a university administrator, you want to pay attention to kind of the student experience, even in situations which you're not in any way legally obligated to. So after October 7th, you know, I had many meetings with Jewish student leaders, and people would say, you know, I feel unsafe. And, you know, and they would say, first of all, it's not just on campus, I just feel generally unsafe now. You know, and so one of the things I said is, you know, I have limited ability, you know, to respond to that, right? But I also, you know, I talked to the head of security, and I said, you know, I want to have a greater presence. So, you know, so even though I actually don't think that people are unsafe on campus, they are reassured by seeing, you know, a real presence of security at a level in which they hadn't seen before.
Yeah, that too creates a tricky issue, because then, and this isn't theoretical, then somebody will say, well, your presence of security was an attempt to intimidate.
Mm-hmm.
Right.
No, I'm not
No,
making,
that's right.
I'm not making that up, right? That I've seen that. And so, you know, you can tell a lot of these like, you know, but, you know.
You feel like you're in a no-win
Yeah,
situation in that way?
That's the takeaway.
Right.
The one thing I'll say that, I mean, I'd say this is maybe dark, that's liberating, which is it's liberating in the sense that I know no matter what I do, I'm gonna get a whole bunch of like hate emails, like, so that's good.
Right.
But the feeling unsafe, I mean, what I'm gonna say can be not derived from the current situation, but if you see a bunch of people who look a certain way, and that makes you feel unsafe, which is true for a lot of people, therefore what? Should we break up? We're supposed to break up the groups? We don't allow it? Like, so that standard, to your point, like people have very different things that make them feel unsafe, and I've heard those things, and so, or symbols, or things.
And the question is, are they unsafe? Do they feel unsafe, or do they just feel spectacularly uncomfortable? That's which is not quite the same thing.
And now it gets tricky, because now it gets generational, because the whole, people of a certain age, they feel unsafe, that gets used in a whole lot of different ways, where it does often mean what we would say is uncomfortable or uneasy, now gets translated as unsafe. So that test, that idea that if you feel unsafe, the university has done something, it's I think a highly problematic thing. Our obligation is to keep them actually safe.
Okay. I do want to, I don't know how much time we have left, Rabbi, before you want to do questions.
We should get into the current administration with a few questions.
Okay, all right. So let's talk about the current administration, and I'm going to try to be relatively neutral about it, which has been more muscular in its enforcement of various, whatever you think about their policy priorities, they have been more aggressive and more muscular in trying to enact their particular viewpoints, and there are a couple places, obviously, in which they've done that with respect to things like viewpoints and ideology and DEI and so forth, and also with respect to their very strong views on at least looking like they are trying to root out anti-Semitism in the higher education, well, in general, but particularly in the higher education communities. So, Bill, you want to talk about some of the tools they've been using? I know the False Claims Act and so forth.
Right. So, so Title VI. So, you know, so private universities are not affected by the Bill of Rights because we're private, but we are affected by Title VI and Title IX. So, you know, because we receive money from the federal government
Of the Civil Rights,
of the Civil Rights Act. So we can't discriminate on the basis of gender, and we can't discriminate on the basis of race or religion. Now, the way in which, you know, it has forever been done is that the Education Department will issue a Dear Colleagues letter in which they offer an interpretation of the law, which you may or may not agree with. And then, they may do an investigation of you and your university. And they may find that you have, in their judgment, violated Title VI or Title IX. And then you can contest that both in hearings at the agency, and then before any action is taken, you can go to court. So the bottom line on that is, it's not like they just say, oh, you're violating Title VI, we're going to punish you. There's a process to determine whether you have in fact violated either Title VI or Title IX of the Civil Rights Act. That's not the way the Trump administration works. The Trump administration says, you violated Title VI, we're going to cut off all of your federal grants. You violated Title VI, we're going to keep you from having students from outside the United States enroll at your school. And, what they're doing is, I think very clearly pretextual. Because it's not like they're going through a process. They're not trying to find out what's actually happening. And they are forcing universities to say, we're going to knuckle under, or you're going to force us into bankruptcy. Because virtually every university is dependent on federal grants of various types. And we're dependent on student loans from the federal government. So Harvard is basically able to fight because it's got an endowment of $50 billion. They are unique. Harvard, Yale, maybe can do that. But, other schools are really they are really in a position where the university is being told you're violating Title VI, and then they have to knuckle under or they're facing bankruptcy because they've already committed the money in reliance on the grants that have previously been given to them, right? And there's no process. And, the reason why, again, to go back to the Harvard case, why I think this is pretextual is, if you go through, the current president of Harvard put together a task force on anti-Semitism. And they made a whole series of recommendations about how to respond, and they've been implemented. The Trump administration, if you look at what they're doing when they cut off Harvard's funding, there's no acknowledgement of all the steps that have been taken. There's no finding that there's in
Harvard's
fact.
report was their main basis that they cited in the letter to Harvard.
Right, because Harvard itself had said, yes, we did some things before that really weren't so fabulous, and we're fixing them all, which of course is the way the federal government has always looked at how and whether to punish institutions of any sort, universities, Fortune 100 corporations, healthcare systems, is if you figure out that you have a problem, or even if a governmental agency figures out you have a problem, if you take the appropriate steps to address it, we're not going to crush you. That's the way the federal government has handled these kinds of investigations for decades and decades. This is not what's happening now.
Right, it's about, if you fix it, that's what we're looking for. We want to make sure that you're not discriminating on the basis of race or religion or gender. Whereas the Trump administration, first of all, the Harvard task force actually doesn't make findings. They're like, this is what we heard. I think they were very careful about that. So, but the Trump administration is, again, taking this stuff, treating it as findings, and rather than trying to say, oh, it's not necessary anymore, because they're the 15 things that you've done, they're saying, we're going to crush you. And the president is saying, he tweets out and says, Harvard, we should take away their nonprofit status because they're woke, right? So, so he's not, he sends out tweets. He's not even saying we should take away Harvard's status because they're anti-Semitic. He's saying we should take away Harvard's nonprofit status because the professors are all crazy leftists. So again, when I say that this is pretextual, the fact that they are not trying to remedy a problem, the fact that they are not acknowledging steps that have been taken, and the fact that the President of the United States is saying, we're punishing them because they're woke makes pretty clear that this is all pretextual.
So I would add one point, and I know we want to do questions, which is, in addition to it being highly problematic that there's no due process or rule of law in any of this, right? It's all, we just attack a university, we announce the verdict, then we announce the crime,
Very
and then the evidence.
Alice in
right?
Wonderland.
Right, exactly. It's particularly problematic because there's no establishment of what constitutes a Title VI violation, right? Normally, I mean, this is what happens with Title IX, whether you like it or not. Universities are investigated, there's a finding of fact, you establish a principle based on cases that have been adjudicated of what is and is not permissible. But because not a single Title VI investigation, as far as I know, this maybe has changed, many have been opened. There's not a single concluded Title VI investigation yet.
Right.
So as a university, we're obviously a low-value target compared to Columbia. But as a university that wants to be thinking about when the day comes that there's a broader analysis, there's nothing to base any opinion on, because there is no Title VI adjudication. There's just institutions that the government has decided are targets, and punishments that have been decreed that are sort of arbitrary. So there's nothing that anybody else can take from it other than hopefully the wheel doesn't stop on you, which is, of course, the point.
Right. I mean, I think a lot of what the administration is doing is they go against some institutions aggressively, not just because they're focused on those institutions, but to intimidate everybody, right? So, we've seen that with law firms. They go after Paul Weiss because Paul Weiss is, associated as a liberal democratic firm. It's very successful. And if Paul Weiss strikes a deal, it sends a message to every firm.
Not to my firm.
But no.
But yeah, right.
Right.
Yeah,
And,
yes.
and some firms fight back, but a lot of firms either enter into the deal or they don't do as much pro bono as they did before. So in the first Trump administration, every law firm of any size was saying, we are, we're fighting the Arab ban in court. Every firm was saying that. Now every firm is thinking, except Arnold and Porter,
But there are others too, but yeah.
is thinking, what am I risking if I have these suits? So, and I think this is all very, very intentional, and it's why they're going after Harvard and Columbia, because if Harvard knuckles under, every other university in the country will be like, we don't have the kind of resources that Harvard does. We've got to give in.
Yeah. So let me make just a two quick. I'm trying not to expand this to the entire Trump administration modus operandi, but I will say that in this particular space, there are three very particular tools that they're using. One is the prospect of revoking federal funding under Title VI or Title IX. The second is when an institution gets federal funding, whether it's to do research on a virus or whether it's to do or to give out grants to students who are low income or whatever particular purpose those funds come to you from the federal government. Every time you apply for those funds and every time you draw down on them, you sign a certification that says we certify in exchange for receiving these federal funds that we are in full compliance, not just with the terms of the grant, but we are in full compliance with federal law, which means every piece of federal law, which includes, for example, whether you are in compliance with the law on DEI, and which is always in some state of flux. And so if the administration thinks that you are not actually in compliance with every aspect of federal law, you have just made a false statement, your institution has just made a false statement to the federal government, which subjects you to treble damages for the money that you took. So you got $1 million grant, and they think that it was a false statement. you owe them $3 million back. So that's a problem. And then the nuclear option, which Bill alluded to a few minutes ago, is that everyone knows what 501c is. And there are all sorts of 501c's. There's 501c3s, which are nonprofit organizations. There's 501c4s, which are advocacy organizations. There's 5s and 6s. What most people didn't know, and I was certainly one of them until last April, was that there is in the tax code 501p. 501p says that you lose your nonprofit status, your tax-exempt status, if the IRS determines that you are either a terrorist organization or providing material support to a terrorist organization. And the threat to Columbia and the threat to Harvard and maybe the threat to Montclair State is if you invite someone onto your campus, or one of your student groups does, who is affiliated with or supports or says things that are vaguely admiring of terrorist organizations, the administration has exhibited an express willingness to say, oh, the IRS could, the president said it, he's tweeted about it, we're gonna deem you a terrorist organization, you will lose your tax-exempt status. And even for Harvard with its $50 billion. Can you imagine if retroactively it was deemed to be a non-tax exempt status and none of the contributions it got from donors over the last 5 years were tax exempt, right? And the administration has been holding that cudgel over the heads of organizations across the country with that idea in mind. Now, they haven't done it yet, but they also haven't invoked the Insurrection Act yet, right? So we don't really know what this portends for a university that even does have the money to litigate, but doesn't have the money to withstand that kind of punishment. It would be litigated, but in the meantime, you don't have your tax exempt status, and you can imagine what that would be like. So anyway, the last thing I want to do before we go to questions is, because Bill is the out-of-town guest, I do want to, and the rabbi alluded to this at the beginning, I do want to read 2 documents very quickly. One is a letter to Dean Traynor, dated February 17th, 2025, from Ed Martin, who was, for a very brief moment in time, the United States Attorney for the District of Columbia. And as many of you know, I was the United States Attorney in a galaxy far, far away from 2009 to 2017. And so I sort of have a little bit of experience with what US attorneys do, and this is not what they do. Dear Sir, which was nice, I thought. Yeah. As United States Attorney for the District of Columbia, I receive requests for information and clarification. No, you don't. I take these requests seriously and act on them with letters like this one you are receiving. It has come to my attention reliably that Georgetown Law School continues to teach and promote DEI. This is unacceptable. I have begun an inquiry into this and would welcome your response to the following questions. First, have you eliminated all DEI from your school and its curriculum? Second, if DEI is found in your courses or teaching in any way, will you move swiftly to remove it? At this time, you should know that no applicant for our Fellows Program, our summer internship, or employment in our office who is a student or affiliated with a law school or university that continues to teach and utilize DEI will be considered. Okay, think about that. No one at Georgetown Law School, if Ed Martin thinks that they're off the charts, gets a job. I look forward to your cooperation with my letter of inquiry after request. Thank you in advance for your assistance. Please respond by Monday, February 24th, which was a week later. Should you have any further questions regarding this matter, please do not hesitate to call my office or schedule a time to meet with me in person. Okay. This was the letter that Bill wrote back in response. Just throw this, let me throw this. I've been holding on to this for the last hour. Dear interim United States Attorney Martin. And he's interim because he gets 120 days where he doesn't have to be nominated or confirmed. I write in your response to your letter dated February 17, which you sent to me via email on March 3rd, 2025. Okay? So 7 days after the deadline to respond. As a Catholic and Jesuit institution, Georgetown was founded on the principle that serious and sustained discourse among people of different faiths, cultures, and beliefs promotes intellectual, ethical, and spiritual understanding. For us at Georgetown, this principle is a moral and educational imperative. It is a principle that defines our mission as a Catholic and Jesuit institution. Georgetown University also prohibits discrimination and harassment in its programs and activities and takes seriously its obligations to comply with all federal and local laws. Your letter challenges Georgetown's ability to define our mission as an educational institution. It inquires about Georgetown's curriculum and classroom teaching, asks whether diversity, equity, inclusion is part of the curriculum, and asserts that your office will not hire individuals from schools where you find the curriculum unacceptable. The First Amendment, however, guarantees that the government cannot direct what Georgetown and its faculty teach and how to teach it. The Supreme Court has continually affirmed that among the freedoms central to a university's First Amendment rights are its ability to determine on academic grounds who may teach, what to teach, and how to teach it. This is a bedrock principle of constitutional law, recognized not only by the courts, but by the administration in which you serve. Your letter informs me that your office will deny our students and graduates government employment opportunities until you, as interim United States Attorney for the District of Columbia, approve of our curriculum. Given the First Amendment's protection of a university's freedom to determine its own curriculum and how to deliver it, the constitutional violation behind this threat is clear, as is the attack on the university's mission as a Jesuit and Catholic institution. Georgetown has one of the preeminent faculties in the country, fostering groundbreaking scholarship, educating students in a wide variety of perspectives, and thriving on the robust exchange of ideas. Georgetown law faculty have educated world leaders, members of Congress, and Justice Department officials from diverse backgrounds and perspectives. We pride ourselves on providing an excellent graduate and professional education built upon the Catholic and Jesuit tradition. Georgetown educated attorneys have for decades served this country capably and selflessly in offices such as yours, and we have confidence that tradition will continue. We look forward to your confirming that any Georgetown-affiliated candidates for employment with your office will receive full and fair consideration. Anyway, so that may not be the reason that the Sterlings decided that Bill would be a great guest, and it's certainly not the reason that the rabbi and I thought that Jonathan would be a great addition to the program. But I hope you got something out of this conversation, learned a little bit, laughed a little bit, and now starting to worry just a little bit more than we ordinarily worry as Jews.
Can I ask a question about the letter?
Yeah.
So you obviously made a very clear point of invoking the Catholic-Jesuit connection because that obviously brings with it a lot of constitutional protection. How much stronger do you think the case is, or you could put it a different way, how much weaker do you think the case is if you stripped away that aspect of Georgetown? Because a lot of religious institutions are, I think, flexing those muscles, but there are a lot of institutions that don't have that in their quiver. So I'm curious how you would see the position differently.
Right, so there are two constitutional points. One is that he's interfering with a religious institution's ability to carry out its mission. So that's a clear violation of free exercise. The other is it violates the institution's ability to determine what it teaches. So, as the letter says, that's a principle that has long been recognized by the Supreme Court. It's actually been recognized that any institution has free expression rights. So there was actually a decision a couple of years ago involving the NRA. So, but it's heightened with respect to the university. So, so there are two, if this had been you wouldn't have been able to make the religious institution point, but you would be able to make the basic constitutional principle about universities have free exercise rights, or freedom of speech rights. Just a couple of other things that I want to highlight. This is not something that you do lightly. when I got this, first of all, I thought my first reaction was, this has got to be a fraud. And actually, if you look on the letter, which you can see online, the U.S. Attorney's seal is like a 7th generation Xerox. So I thought, this is just some crazy person like getting the U.S. Attorney's seal and putting it on a piece of paper.
I got 2 of these for 2 of my clients,
that
and I
right?
exactly the same
Yeah,
reaction.
no, it's amazing. And then, people convinced me that this is actually genuine. And my reaction right away is, this is clearly unconstitutional, both because we're a university and because we're a religious institution. You don't do this lightly because, this is an administration that uses intimidation. So, my wife and I, we had the conversation, and I said, I won't do this. This is the right thing to do, but I won't do this if you don't feel comfortable. And Allison said, this is the right thing to do. But then, our old department, there was a pizza delivery afterwards. They had my cell phone. The pizza deliveries are ways to intimidate you, to show they know where you live. So, this, again, it's the kind of thing that, you're dealing with, and it's an administration that prosecutes people who they disagree with. So you don't do it lightly, but, this is a point in which, it's crucial to do it because, other people follow suit. One of the Georgetown alums came to me shortly thereafter, and he said, I worked for a government agency. I was told by my boss I had to fire 2 people. And then I got the letter, and it said these people are being fired because of performance issues. And I went and I thought about it, and he said, because you inspired me and because courage is courageous, I went to my boss and I said, I will not sign this. So it builds over time. And again, it's not easy, but it's the right thing to do. The one thing that I would say on a lighter note, because I think we don't want to end on kind of like a physical intimidation point. When I read the letter to Allison, my wife, and she said it was the right thing to do and I should send it, she said, I have one suggestion. I said, what's the suggestion? Call him interim U.S. Attorney. And call him interim U.S. Attorney several times. So the crowd, yeah. So I have to say, I'm a small enough person that it's a little irritating to me when people say, loved your letter. You know what I really liked the most? The way you called him interim U.S. Attorney.
But you're a good enough husband to tell a crowd of 70 people that when she's sitting in the front row. That's a mensch.
So we kind of make a commitment always that our programs end by 9. We have 7 minutes until 9 o'clock, which means we probably can only take 1 or 2 questions. So questions. Okay.
I guess this is the hardest question, which is what happens if everybody just says, no, we're not capitulating, like across the board? Is that even possible?
It turns out I don't think that has to happen. I mean, I'm not a predictor of how things work out in the end, but there is, for example, I'm talking to a lot of people in a lot of contexts about autocracy and the rise of autocracy and what happens in anti-democratic regimes and how things work. And it turns out that like, for example, we said that if people start to protest, right? I mean, there were 50,000 people out in Minneapolis on Friday before the killing, before the execution of Preddy. 50,000 people, the wind chill was 45 below, okay? Apparently, and people have studied places like Poland and other societies where they've rebelled against authoritarian. You only need like 6 or 7% of the population to show up. So I don't know that you need everyone to say no. You just need businesses of consequence to say no, Harvard to say no. It is true that Harvard has more money, but Harvard saying no bucked up a lot of other institutions. The president of Princeton, the president of Wesleyan were awesome, and they weren't even threatened, but they spoke up. So I think, as Bill said, courage breeds courage. And I think once people set examples, which of course is the whole point the other way, if we can intimidate X, everyone will cave. But if 5 or 6 people stand up, maybe not.
first and foremost, just thank you for this conversation. I think it's really important. One of the questions that I have is, one of the challenges that universities face is the weaponization of misinformation about events at universities on social media, and then the reputational harm that it does to institutions, which can't correct the record necessarily because sometimes privacy is at stake. How do you deal with those kinds of situations?
So we try to maintain lines of communication with affected constituencies, religious leaders in all communities, elected officials, so that we can't communicate with everybody, but we can try to communicate. And when we get actual emails from actual people, we get robo emails, lots of robo emails. We can't answer them. But we do try to be responsive, and we do try to put out real information. But the reality is, you know this, that the lie circles the world before the truth puts its pants on, or whatever the phrase is. And so you just have to accept the fact that there's misinformation. By the way, it's not just social media, it's media. The standard of what is published on any number of subjects is so low that this is one of the great challenges, that you deal with people who say, I heard that.
Yeah, and I think, so I was dean for a long time. One of the biggest changes during my tenure as dean was the rise of social media, right? So I became a dean first in 2002. You know, you didn't have to worry about that. That wasn't something that even crossed your mind. You know, social media, you know, something that we said right now, you know, could be on social media, you know, before I drop the mic. You know, and so that really kind of changes the world in which you live. You know, I think so one of the things actually that my associate deans, you know, always say, you know, how long are you able to stay in this job for so long? And the answer is, I don't look at my social media, because inevitably, and this goes back to one point that you said at the beginning, you know, people are going to be, you know, some people are going to like something, some people are going to hate it. And, you know, we're all in a position where, you know, if 9 people say this is great and one person say this is awful, that's the one you remember. So I think just another thing for academic leaders that I think it's important is to kind of keep in mind that, you know, even though this can, you know, you have to be attentive to it, that, you know, you shouldn't keep it from, you know, having you do the right thing.
The one thing I'll say to that is, I don't read the social media about me. My kids will tell me if something really horrible is said. But we do pay attention to the social media, because even if it's misinformation, we want to know what misinformation is out there. I don't think you can afford, as an institution, forget about but as an institution, you have to know what's being said. You have to know what your students are saying. You have to know what the community is saying. It is now part of the institution's responsibility to pay
Right,
attention.
and so and just to wrap before, you know, and that's why we have a communications office, you know, so that they can stay on top of, you know, issues like this. But I just, you know, it is a big concern. So, you know, I think that's a very important question to raise about how you respond to that. Rabbi?
So this is our final question. We just heard from Rutgers Newark. Now let's hear from Columbia.
Yeah, longtime Columbia employee. It's been a rough couple years, we'll say. And the gates, by the way, are still locked as of today. So my question for you is, Columbia is one of the institutions that actually said yes and did a deal with the devil, so to speak, to the tune of $221 million. I'm curious as to your opinions as to whether or not that was the right thing to do, given that we don't have the deep pockets of Harvard.
You know, I think you have to fight this, you know, and so when universities have fought, so far they've won, right? So Harvard has fought, and they've won at the district court level. The UC system has fought, and they've won thus far. So, you know, I think, you know, I have to say, you know, what Columbia did, you know, it was very concerning, you know, on many levels, you know, and one is that, you know, part of the deal involved, you know, academic receivership of parts of the Columbia curriculum, you know, so I think kind of at its core, one of the things that a leader has to think about is, where do you draw the red lines? And so first, I think if I'd been, making the shot, I would have fought that in court. And then, if you're in a position where for some reason you decide to have to do a deal, to have the administration tell you what you can teach, that's a red line. And that's something that you can't allow to happen.
So I don't feel like I know quite enough inside, and to fully analyze it. I do think it's useful to think about what they were facing, right? So how many people drive by on the West Side Highway, all those buildings that Columbia built in Harlem, right? So that was largely debt financed, and so they have bonds that they have to pay. And their expectation was that the revenue that was going to pay those bonds was the overhead on all of the federal research grants. So I suspect that they were contemplating and did the math on what was their tolerance, their fiscal tolerance to be able to sustain the payments that they had to make given their situation. I suspect that was part of, and so that's the calculus that they're making. It's interesting because we think these people have more money than God, and obviously from my perspective, they do. But they also, right, like a lot of people who are rich, they have a wealthy lifestyle, right? And so, Columbia has always done things that are a little bit more money generating than some other Ivy League institutions. And it's not a coincidence that Columbia all of a sudden decided they need to serve humanity by increasing the size of their undergraduate population. So I think that speaks to some degree to the financial pressure that they face. So I agree on principle. I'm just trying to say I kind of wonder what the calculus was, and so I don't have a conclusion. I tend to agree, and I tend to agree that the terms that they accepted were pretty significant.
I just want to, so two things. One is, if you fight this, you're going to win. I think the law is clear. And so what they're doing in the Title VI area is clearly illegal. The letter that I got from the interim U.S. attorney is clearly illegal. So I think, it's not like Columbia is making a decision where if they go to court, they're going to lose.
No, that was.
I understand the calculus, but they're going to win, right? And then the other thing that is very important is, I think we could be on the verge of autocracy, right? So this is, people die for democracy. And if you can't pay your bonds, that's a terrible blow for the institution, but you have to realize what the stakes are.
Yeah. I'll make one final observation on this point, although I probably won't get the round of applause that Bill just did, but I'll say it anyway. I can't comment specifically on the Columbia situation because I have friends on the board and we do some work for Columbia. My firm does some work for Columbia, although we were not representing them in that matter. But I will say this, at the time, to go back to the media point, the press was reporting some facts that sounded quite awful for the university in some way. Harvard's facts as reported were not as bad as Columbia's facts as reported. That's one thing. The second thing is, I don't think we knew several things about this administration when Columbia and Paul Weiss made their deals in March or April. We didn't know they were going to blanket every industry with the same kind of stuff. We didn't know that they didn't care when they lose. We didn't know that they don't have the bandwidth, the resources, and the money to keep going in all of these places, the most important. It is true that the federal government has limitless amounts of money, but they don't have limitless attention span or lawyers or patient judges out there who are willing to listen to the blank that they spew. And so I do think that over the last year, as what I will characterize as the resistance has gotten its footing and has become more organized and has become more resolute and has become more outraged, I do think the landscape has changed. And I do wonder, in response to your question, that if they did the same thing today, would that deal get made today? And I think the answer might be no. And so I think that matters a lot. So if there's so I do think, I mean, if you look at what, First National Guard, we'll take it. Second National Guard, not so much. Third National Guard, get the heck out of my state, right? So there's a difference, I think, in the way people are feeling about this and how emboldened people are to fight back. And I do think that that matters whether you're in the university setting, public university setting, the private university setting, the law firm setting. I think things are, they feel a little different in that way.
So thank you to our three panelists, and make sure to meet somebody new on your way out the door.
That was great. Thank you very much.